Well, again, thank you for joining us tonight. My name is Katie Jones. I am the Chief Program Officer of Organizational Employment and Advocacy at BCI. To get us started, little housekeeping. So everyone will be muted, and if you have any questions, you can enter that in the Q&A box, which is located at the top of the screen. You can type those questions in. Ask that if they're specific in nature, that you hold off, and we'll provide our speakers information. You can call her directly for those specific questions, but any general questions that you may have, feel free to put those in the Q&A box. Today, we are navigating the complexities of guardianship and conservatorship, crucial areas for everyone, but especially those getting ready to graduate from high school and transition into adulthood and independence. And this evening, to provide the information, we have Lorna Frahm, and she is the managing partner of the Frahm law firm. She is deeply committed to the community and disability advocacy, having served at organizations like Emmaus and BCI. At BCI, she joined the board back in 1999 and was elected board president in 2003. So without further ado, we'll go ahead and get started. And Lorna, you can take it away.
Thank you so much, Katie. Tonight, we're going to talk about guardianship and conservatorship. And what I'd like to do is just kind of walk you through the maze of the state statute. If any of you are high achievers, you can look at Chapter 475 of the Missouri Revised Statutes. You can get those online for free, Missouri Revised Statutes, Chapter 475. About 5 years ago, there was a great big overhaul of this area of the law, and I'm going to try to point out new things that have come into place since that time. First of all, let's talk about guardianship. The way to establish guardianship is you must file a petition in the court in which your child or grandchild or nephew, whoever your family member is, where that person lives. So let's say you live in St. Louis County and the person you're filing for lives in St. Charles County. I happen to practice in St. Charles County, and I know many of you on this webinar may live in different counties, but whatever county you live in, where the person lives, that's the county in which you filed the petition. Now, there are slight differences between counties. For instance, in St. Charles County, they won't let me file the petition until the child is 18 years of age. And that makes some parents very concerned because they'll say, well, what if something happens between the time the child turns 18 and the time I can get the hearing? So the courts are aware of this, and they do pretty much everything they can to get that hearing held as soon as possible. We have what's called a commissioner in St. Charles County now, which is one step kind of the helper for the probate judge. And we hear our hearings on Fridays. But in St. Louis County, you could have hearings on any given day, and it might change timing in St. Louis County or St. Louis City. Now, when you file the petition for guardianship, there'll be a filing fee. And in St. Charles County, the filing fee is $343.50. And that's a very high filing fee because most civil actions are well under that. And the reason the filing fee is so expensive is because that fee will include the cost of hiring an attorney to represent your loved one. And we'll talk a little bit more about that. Also, there'll be a fee associated with getting the person served. And the person will be served by the sheriff of the county in which the person that you're filing for resides in. For instance, in St. Charles County, the fee is right around $39 to get the sheriff to do the service. Before you file the petition for guardianship, you need to take a look at what the standard for guardianship is. The court will ask whether the guardianship will provide one of two purposes. Will the filing of the guardianship and the granting of the guardianship provide a mechanism to provide for the safety of that person that you're filing for? It doesn't matter what you want. What matters is what's best for the protectee, the person you're filing it for. What the state statute calls this person is the incapacitated person. And there's a very broad definition of what makes someone incapacitated. And basically, it boils down to whether or not that person has the physical, mental, or cognitive ability to manage their financial affairs or to provide for their health and safety. Does that person have the ability to communicate with their physician and evaluate the information that the physician provides to them? Now, before you file for guardianship, you might want to talk to your child. I'm going to say child, but it could be grandchild, it could be niece, it could be nephew, it could be sister, brother. Maybe I'll just say your loved one. You really need to talk to your loved one's primary care physician. That might be an internist, it might be a psychiatrist, whatever physician you take your loved one to for any type of medication that they may need based on whatever physical or mental problems or conditions they may have. Because there may be a way around filing the guardianship altogether, which it might be best for your loved one. If your loved one is an individual who's high functioning, who can evaluate information, who is compliant when on medication, you might want to explore the idea of using a durable power of attorney for assets and a healthcare directive for healthcare. Now, why doesn't everyone just do that? Well, in some instances, it's just not practical because it may be that the individual doesn't have the capacity to enter into a durable power of attorney or sign a healthcare directive. Another issue is even if your child signs a durable power of attorney, which gives you the right to make financial decisions for your child, that does not take away the child's ability to make those decisions on their own. I'll give you an example. I'm going to reveal my age here a little bit. When I was 18 years old, I was walking through Famous and Bar. Many of you might know that's Macy's now. And someone came up to me and said, "Would you like a credit card?" I said, "Well, I'm only 18. They said, "Well, you're 18. You can get a credit card." So unbeknownst to my parents, I applied and obtained a Famous and Bar credit card. If your child is 18, they are considered an adult by any standards under the state of Missouri. They can enter into a contract. They could get a credit card. They can sign their name. They could go to a bank, open up an account, sign a check, and distribute money. So sometimes, based on what is going on in your loved one's life, guardianship protects them, a conservatorship protects them from making financial decisions or medical decisions that might not be in their best interest. So again, the place to start is with the doctor who assists you with their health care. Because one of the things you're going to have to provide with the petition are what's called medical interrogatories that are signed and notarized by a physician, Missouri licensed physician. And in these interrogatories, the key question is, do you consider John Smith a person who is unable by reason of mental disease or defect to manage his or her financial affairs? And the answer has to be yes on those medical interrogatories. The doctor has to make a decision, medically derived decision, that your loved one lacks the capacity to manage their affairs. Now, some counties like St. Louis County, I can't even file the petition for guardianship until I have those interrogatories signed by the doctor. St. Charles County will still let me file the petition and then obtain the interrogatories prior to the hearing. But those are critical. The state of Missouri does not require that doctor to show up to court and testify. That would be very expensive and very hard to get doctors to come to court on Friday mornings and take hours out of their practice to do that. So they will fill out these medical interrogatories and they will be signed, as said, in front of a notary public. Those will be admitted into evidence. So when you're thinking about when is the appropriate time to start the process, this would be something to think about. And maybe if you take those interrogatories to the doctor with you and your loved one's appointment, might have better chance of getting them back quickly. If I send the medical interrogatories to a doctor who doesn't know who I am and asks for this information, it sometimes does slow down the process. If you are a married couple or if you are a sister and a brother of someone who's looking to establish guardianship for your loved one, you have a decision to make as to whether you want to have a single guardian or you want to have co-guardians. It's my recommendation, if there are two people who are willing to serve, husband and wife, brother, sister, or whatever, I think a joint guardianship is a great idea, just because in case something happens to one of the guardians, or one of the guardians is out of town on business or on vacation, you've got someone else who is available to communicate the decisions that are needed for your loved one. This is one of the changes that were made about 2019. These changes came down the pike right before COVID. If you are going to be joint guardians, let's say you're husband and wife, you have to tell the court whether you want to be able to act alone, independent of each other, or if you both have to sign. This sounds like a pretty simple question, but in today's world, let's say you're a parents of a disabled young adult and you're divorced. So you don't even, both of you don't even live at the same time with the guardian. It might make it much easier if either of you could act independently. If you take your child to the doctor, only one of you has to, or not has to, but either of you could communicate what you want, what you think is in the best interest for your child. Even if you're not divorced and both of you are parents, or you're both a brother and a sister, I usually have my clients sign an affidavit that says either of them may act alone, so it doesn't require both signatures. If you think about that, that just kind of makes sense. Until your child is 18, if you've got a 5-year-old child or a 17-year-old child, both parents don't need to be at the doctor's office to make decisions for healthcare. So it just makes sense, I think, that if you are going to have a co-guardianship, that you make it such that either of you can make the decisions without the others. At the court hearing, I would call it one of the most informal court hearings that I do. I do a lot of probate litigation, and these hearings are very quick. Don't be afraid about going to court. They take about 5 to 10 minutes. But in St. Charles County, we have them always on Friday mornings in front of Commissioner Tony Linson. The whole hearing is very, very short. The same questions are asked of every litigant. So if you happen to be there where there's 5 of 6 of them on that same day, you might get to hear 3 or 4 of them going on before yours. The ones for 17-year-olds turning 18 or 20-year-olds turning 21, whatever time frame it is that you initiate the guardianship proceedings, are good, feel-good type hearings. It's not the type that you have when you've got an elderly person who is suffering from dementia, or an adult who's suffering from mental illness like schizophrenia or something, where it's a taking away of an adult's rights. I mean, this is parents who are siblings or grandparents who care about this individual and want to make sure that their life is not made even more challenging by the fact that they have no one out there to communicate their healthcare decisions for them. So if it's a joint guardianship, both the husband and wife or sister and brother will get on the stand one at a time, and I'll ask questions such as their relationship to the person. They're not doctors, but I'll say, could you describe to the court why Joe is unable to manage his own health care? And I might give an example such as if Joe is on 4 medications, does Joe know what time of day and what dosage to take his medications? Very simple things that demonstrate to the court that Joe does not have the ability to manage his own medical decisions. If a conservatorship is required, and I'm going to talk much more about conservatorships, I'll ask questions such as, if Joe were to go to Quick Trip and buy a QT fountain soda and gave the clerk $5, would Joe be able to understand if the change the clerk gave him back was correct? Just simple, everyday things that will demonstrate to the judge why you're there in court to seek that guardianship. Of course, the medical interrogatories have been admitted to court as an exhibit, and the judge will take judicial notice of the medical interrogatories, which state that Joe does need a guardian. If the interrogatories come back and say Joe doesn't need a guardian, I'm gonna call the doctor and say, was this a mistake? Did you say yes when you meant no, or say no when you meant yes? And if the doctor says that Joe doesn't need a guardian, I don't have a prima facie case to go in front of the court. So we might go back and look at, well, is there a least restrictive way to provide care for Joe? Could we do a durable power of attorney and a health care put somebody else on his bank account that requires 2 signatures. What could we do in order to give Joe some protection, but not have a guardianship and a conservatorship? So don't be worried about the court hearing. Most of my clients that go, this is their first time they've ever had to testify in court, and it does worry them a little bit. I always ask them, if it's a husband and wife or a brother and sister, who wants to be my star witness? And the reason I ask that is if I put the wife on the stand and she testifies, what I could do then is ask the court to do what's called an offer of proof. And that basically says that if I put the husband on the stand and I asked him the same questions, his answers would be substantially the same. It just saves time in the courtroom, because many times if the court has 2 dockets, maybe a 9 o'clock and a 10:30, and there's lots of people there who are there to get their cases heard, and they just like to get those moving and get them out. Now, when I talked about service of summons, this is something that can really, if you don't know it's coming, can be very distressful for your family. There is a state law that says that Joe has to be served by the sheriff. So the sheriff will come to your house in sheriff regalia, full uniform, knock on the door and ask to see Joe. If Joe is available, Joe will come and the sheriff will hand him service of this petition that you filed. Now that upsets people. It could get somebody who is sensitive, could be alarmed by that. So the fact that you have knowledge that that is coming, and you can talk to Joe and explain why that's happening. Now, if the sheriff knocks on the door and Joe's at work at Boone Center, or Joe's bowling, or Joe's anywhere, any adult over the age of 18 can accept service of process for Joe at the house. So that's just because if we had to serve everybody every time, we would never get service done. But I always tell my clients, please let Joe know that this is going to happen. This sheriff is our friend. This sheriff is there to help him. Joe has not done anything wrong. I mean, most anybody would think if a sheriff knocked on my door and wanted to serve me, my immediate thought was I've done something wrong to be handed a service of summons. So that's one thing I really stress with my clients, to let Joe expect that to come. Now, I talked about the filing fee being so high. That's because there's going to be appointed a guardian ad litem for Joe. Who this guardian ad litem is another attorney in the county who has taken training on guardianships and conservatorships. This guardian ad litem must meet personally with Joe. Sometimes the attorney will ask you to bring Joe to his office. Sometimes the attorney will go to your home and meet with Joe, because they might want to see Joe's surroundings. Is your house the least restrictive environment for Joe? Does Joe have 5 siblings in the house and 2 cousins living there? And so some attorneys are different. There's no requirement, except they must meet with Joe 24 hours before the hearing. These attorneys are not doctors. The interrogatories from the doctor establish that Joe needs a guardianship. What the attorney does is meets with Joe, asks simple questions, maybe who's Joe, how's it going today? Do you like your mom and dad? You want them to be your guardian? Hey, Joe, do you know who the president is? Joe, do you go to school if you're 17? What subjects do you like? They just try to build a rapport. It's not an interrogation where they're trying to make Joe feel bad. And all that attorney does is shows up at the court hearing and gives a report to the court based on what they saw of Joe. I mean, if Joe is communicative or not communicative, if Joe's not communicative, it's a very easy report for the guardian ad litem to give. But if Joe can talk, and we hope Joe can, and banter back and forth with the attorney, Joe just gives his impressions. Joe's attorney gives the impression to the court as to whether or not, in his opinion, a non-legal opinion, whether it be in the best interest of Joe to have a guardian established. Now, Joe has rights. When he gets served with a summons, some of the rights Joe has is he has a right to appear at the hearing. Joe has the right to a jury trial. Missouri takes this very seriously. When a guardianship and conservatorship is established, you are taking away rights of someone who's 18 years of age. So they take this very, very seriously. Sometimes Joe might want to go to the hearing just to see what's going on. Joe may waive his right to go. He could tell his attorney, I'd rather go to school. I'd rather go to work at Boone Center. I don't really want to go to the hearing. That's fine. Joe can waive his right to be there. The only time I've ever had jury trials is when it's someone who has mental health issues, who doesn't believe they need a guardian or conservator at all, even if the doctor says they do. They do not want a guardian and conservator. So I've had jury trials, but it's very, very rare. Could be very, very expensive if that happens. So you've had the court hearing. Let's say Joe's parents are both wanting to be co-guardians. So we have the hearing and the judge grants the motion for guardianship. Usually the judge will do that right from the bench. It's not like you have to wait around to hear whether or not it's going to happen. The judge will say, based on the evidence and the medical interrogatories, I established that Joe needs a guardianship, Joe needs a conservatorship, or both. So that ruling will come from the bench. In about the next week, the court will mail out the letters of guardianship. They will have a gold seal on them if they come from the court. Those are like gold. They're saying these are important. So I always ask my clients, keep those in your possession, make copies. Give a copy to Boone Center, give a copy to Joe's doctor, give a copy to Joe's school. Whoever interacts with Joe gets a photocopy of those letters of guardianship. Now, I explain to my clients that if you are appointed guardian for Joe, you have an obligation once a year to file an annual report with the court. In this annual report, you are going to say where Joe is living. If he's living with you, that's fine. If you've moved Joe from your house to a ISL or a community home, you need to let the court know where Joe is living. And you say to the court that this is the least restrictive environment for Joe. Now, with young people, a home or a group home or independent living, an apartment with another person or independently, that's pretty simple to understand. That's the least restrictive environment. But when I'm talking about guardianships for elderly people, maybe there is an independent living is better than assisted living, or assisted living is maybe just a little bit or least restrictive than skilled nursing care. So, but for young people, either your home, if that's where Joe is, or an apartment, if Joe can handle an apartment or a group home setting. The main thing is the state of Missouri now has an interest in Joe. They want to know where Joe is. So once a year, you do not have to hire an attorney to fill this out, but you must file it. If you don't, you'll be considered delinquent. The court will order you back to court to explain why you did not file that. And one last thing with this segment, single versus joint guardianship. I'm maybe focusing a lot on the 17-year-olds, but let's say you're a parent and you've been guardian for Joe for 40 years. And now perhaps you've lost your husband or your wife, and now you're a single guardian. You can petition the court to have a successor co-guardian be appointed so that there's no interruption. I'll talk a little bit more about that. So now let's talk about the types of guardianships. There are a full guardianship, which I probably do 80% of. What a full guardianship means is that the person is determined to be totally incapacitated and need help with managing all aspects of their life. Now, the law does not favor full guardianships. The law actually favors limited guardianships. And by that, I mean there are certain things that the state of Missouri would rather your child or your brother or sister retain. Some of those are retain the right to vote. So that's going to be a question that the guardian ad litem will ask Joe. Joe, would you like to be able to vote? If Joe says yes, then the guardian ad litem is going to ask that Joe be allowed to retain that right. The other right is the right to marry. Marriage is a contract in the state of Missouri. If you have a full guardianship, Joe will not have the ability to enter into a marriage contract. So again, Joe's attorney remember the court-appointed attorney, will ask Joe, would you like the ability to get married? If Joe says yes, then his attorney has to tell the court that Joe would like to be able to get married. And the third one is driving a motor vehicle. And this question comes up all the time. Joe may want to drive a motor vehicle, and he may tell his attorney that, but Joe may not have the physical or mental ability to do that. So what the guardian ad litem would say is Joe would like to reserve the right to drive a motor vehicle if he can otherwise pass the written and driving test that anyone else would take in order to have a license to drive a motor vehicle in the state of Missouri. So sometimes I've had situations where parents will say, oh, no, I don't want Joe to get married. Oh, that would be awful. But Joe wants to get married. Joe would like to reserve the right to do that. So the judge will fashion the court order based on what the judge thinks is the right thing. If Joe really wants to get married, but Joe's parents think that's not a good idea for Joe, the judge may give great deference to the parents because they know Joe better. So they might say, at this time, I'm saying Joe is not engaged to anyone. He doesn't have anyone he wants to marry right now. I'm going to say Joe does not have the right to marry, but if he should want to, he has the right to come back to court and petition to have that limitation removed. That's kind of a happy medium. So that if the right person came along and Joe's parents felt like that, yeah, this would be good for Joe, then they might be fine with not contesting the ability for Joe to get married. Now, I have had cases where we have very high functioning people who have autism, and they work and they have money, they have bank accounts. A complete conservatorship on their part would just, take away rights that they really should have. So the judge sometimes will fashion an order that says any single expenditure over $500 would require the conservator's permission or authorization. But if Joe wants to buy tickets to go to a ball game or buy an iPad, Joe works, Joe would have the ability to do that. Why the dollar limit? This would keep Joe from being taken advantage of by someone who might want to take him to a bank and ask him to take money out to protect his mother. I mean, all of us are subject to scams. I mean, any of us could fall victim to a scam. But Joe might be a little bit more subject to that, and we just want to protect him because he does work hard, and he does want to have that money to do things that he wants to do with. So backing up to successor guardians, this is really simple. So if husband and wife are guardians for Joe, and husband passes away, and now mom wants her oldest daughter to become co-guardian, and oldest daughter, Joe's sister, wants to become co-guardian, it's a very simple process. We just petition the court. We don't have to have a hearing again. We just petition the court and we let the court know that Joe's sister, Jean, has a job. She's a good citizen in the community. She wants to help her mom and her brother. And if she matches, doesn't look like she's in it just to take over his money, the judge will issue an order and no hearing is even required. Okay, now I'd like to move on to termination of guardianship. This is another push that came about in 2019. Remember, I talked about the court really favors limited guardianships if that's what's appropriate for Joe. Part of the court hearing is the question that I asked my clients. I just had to start asking in 2019 is, if you are appointed Joe's guardian, will you take every steps for rehabilitation for Joe? If the doctor says this medicine might help, or if this physical therapy, or if this program will help Joe habilitate him, if you're his guardian, will you make every effort to follow that recommendation? And of course, my clients say yes, because if they say no, they're probably not going to get appointed guardian. So the court wants restoration of rights. What that means is, let's say you do have a full guardianship appointed for Joe, but some medication helps Joe, or something else happens that he is able to habilitate, then you can go back to court and that person can have restoration of rights. So it can happen. I have not seen it that often, but it's a good thing, I think, that this isn't forever. Just because you are incapacitated now or you can't do something now, it doesn't mean that you can't. Maybe you've got some rehab or call it what do they?
Rehabilitation.
Rehabilitation, right. I mean, so it's a good thing to have that. And it shows that Missouri is forward thinking in this area, which I appreciate that if there is a reason to go back to court and restore some of those rights, that's a good thing. Now, remember I said you have to file an annual report where Joe is each year. When Joe dies, you have to let the court know that Joe's not here anymore, because they're going to keep looking for that annual report. And again, the state of Missouri now has an interest in Joe. They want to know where Joe is, and if Joe were to pass away, you need to let the state of Missouri know that. All right, now I'm going to move into conservatorship. Guardianship basically deals with healthcare, decision-making of where you live. Conservatorship is about conserving assets. So a lot of times, I would say 80% of my clients, when I file a petition for guardianship and conservatorship, I say I would like conservatorship established as well. I want something in the record that shows that Joe can't make change from Quick Trip. I want the court to know that Joe needs help managing his money. Even if Joe doesn't have money, let's say Joe is 17 and he doesn't have any of his own assets, I want that hearing held in case Joe were to come into assets, so that we don't have to go back to court and have that determined. So if Joe is a typical 17-year-old without assets, and when he turns 18, you intend to file for Social Security, what I ask the court to do is say, Joe has no assets at this time. And when you do grant the guardianship, and when he does turn 18 and his parents or his sister file for Social Security, he's never going to have over $1,000 in his bank account, because they're going to use that money for his care. So I would like an order from the court of something called no further process. Very important, because if I don't ask for that and there's a conservatorship established, every dime that you spend of Joe's money has to be reported, has to be filed on an annual basis with the court, and the court will require that whoever is appointed as his conservator, post a bond. A bond is just a insurance policy that says you won't run away with Joe's money. So it's a totally expense that is just totally not needed. Now, if Joe has money of his own, let's say Joe's grandparents meant well, and I'll talk more about this later, and left him money, or when he was little, parents and grandparents gave him money for his birthday and it's in this account. Well, there might be a reason then that you would have to have a conservatorship. Or let's say Joe has a disability that was created because he had a car accident when he was 7, and now he's developmentally disabled because he had a brain injury. There's many types of reasons why Joe might have money of his own. And if that's the case, then a conservatorship might be required. Or I would argue to the court, I try to do anything I can to avoid it. I would ask the court to put that money in a restricted account that could not be touched without a court order, so that he would not require a insurance policy, a bond, to be determined. When you fill out the petition for guardianship and conservatorship, there's a whole page about assets. It'll ask about Social Security, disability, how much is in the bank account. So that's going to determine, the court will see that, and they'll inquire about whether or not a conservatorship is required. I have an elderly client who has a conservatorship right now. She's been in the conservatorship for 5 years. She's in a nursing home, and we have to report to the court every dime that is spent. So it takes lawyer time to do that, which I don't like having to charge clients for, but the individuals get the information, they bring it to us, we file it with the court, and that just eats away at their assets. So anything we can do to avoid a conservatorship is important. Now, the state of Missouri back in 2019 really wants to look out for Joe. They don't want anybody being Joe's conservator who doesn't have Joe's best interests at heart. They might just like Joe's bank account. Okay, I can't be any more direct than that. So if you are not 1 degree related, within 1 degree of Joe, if you're not Joe's mom, dad, sister, brother, or child, The courts now require that you file reports before they appoint you as his conservator. They want to see a criminal background check. They don't want to see it, they require it. They want to see a credit check. They want to see I have to contact the Missouri Highway Patrol for a criminal background check. I have to call credit reporting service and get a credit check on you. If you are not mom, dad, sister, brother, son, or daughter, if you are grandparent, if you are aunt, if you are grandson, you have to fill out these reports and provide them to the court, or you will not get appointed. So again, I've snuck back in this word durable power of attorney here. I have no problems with guardianships for anybody who needs one, because there's not all this reporting or bonds or anything. But if there is any way at all that Joe can sign a durable power of attorney and give someone the ability to manage his financial affairs for him, it's a very, very good alternative for a conservatorship. But again, the downside is it does not protect Joe from someone taking advantage of him, because just because you have power of attorney for him, Joe still has the ability to sign contracts and do things that he otherwise would do. So next thing I want to talk about is special needs trust. This kind of is not the exact topic here, but I think it's something that all of anyone who works with people who have special needs of any sort needs to understand enough to know to talk to. Let's say Joe is your son, you need to talk to your parents. Because so many times grandparents think, oh, Joe has these special needs. I'm going to provide for Joe in my trust or in my will because he has needs. He's going to need money to take care of things. That is about the last thing you want to have happen, but it happens. I have probably 20 times a year this happens where an aunt or an uncle or a grandparent leaves Joe money. And if Joe inherits money, guess what that does? It takes Joe off of his ability to receive certain Medicaid benefits for health care and perhaps other benefits that are provided to him through any state, federal, local, or private charity. So when you have a child who has special needs, it's important that you talk to other family members and also for your own. I have one client who worked at Boone Center whose parents were divorced. Father worked at Boeing, had never been remarried, and listed his children as his beneficiary of his 401k. Well, his children were a daughter who was typically developing, and it wasn't really Joe, but another young man who inherited quite a bit of 401k money. So that money would have kicked Joe off of all of his benefits. But what we were able to do is something called a self-settled special needs trust, where Joe's mom, with my help, created a trust. We put that money into Joe's special needs trust. It was an irrevocable trust, which meant Joe's mom could not change it. Joe could not change it. And it said that it would provide funding for Joe for things that Medicaid and other programs did not provide for him. Things like vacations or computer equipment or clothing or haircuts or dental work. But at Joe's death, anything that's left in that trust would be paid back to the state of Missouri to the extent the state of Missouri had paid out benefits to Joe. Kind of complicated, I know, but I just want the whole point of that is if your child or sister or brother did happen to inherit money or get money for any reason, don't worry, the end is not there. There are things you can do to make a self-settled special needs trust. The more typical special needs trust is the one that I call the TIDRO trust. If you are parents and you have a child who has special needs and who is on any type of government benefit, you can create a trust for your child, and perhaps you've got typically developing children. All of them can be included in your trust, but instead of your developmentally disabled child receiving their inheritance all at once, you put it in what's called a special needs trust. The trustee will only distribute money to Joe if they find that the trustee finds in their absolute discretion it's in Joe's best interest to have that money. I tighten up the language and it says, if Joe is receiving benefits from any federal, state, local private charity that's providing that already for him, then this trust money is only to be used to supplement those benefits and not to supplant. Supplant is a fancy word that says take the place of. So Tidrow trusts have been recognized in Missouri for about 40 years. Tidrow was a doctor in the state of Missouri who had a special needs trust, and he wanted to leave money to his son, but he didn't want that money to all be used up from, Medicaid or other programs. Since Dr. Tidrow was the one who earned the money, it was his money, the state of Missouri created this Tidrow standard that says that you can do that. But picking the trustee on a special needs trust is very important. There are certain trust companies who understand those rules, or if you choose another son or daughter, make sure they get education on how to make the decision on whether or not to distribute from those special needs trusts. So grandparents, again, are great joy, wonderful people, but you need to educate your parents, if you're the parent of a special needs child, on why their best intentions could create more problems. What I've done with grandparents is, if they want to create a special needs trust for their grandson or granddaughter, we can create it now during their lifetime, and it won't be funded until the grandparents are deceased. That's the way they know that they can name that trust as the beneficiary of a certain asset to go to Joe, and then it goes to Joe at their death. Special rules for 401ks and IRAs. I don't know if any of you have heard of what's called the Secure Act. It relates to distributions of 401ks. For the most part, it's not a good thing. What happened is, it used to be that you could name your children as beneficiaries of 401ks, and they could stretch out those payments over the oldest child's life expectancy. My mom passed away in 2006. She named me as the beneficiary. So every year I take a required minimum distribution based on my life expectancy. And the count has grown since 2006 to where even when I take something out in December of each year, it's still there. So I've been able to do this for a number of years. When the Secure Act came along, they got rid of that rule, and they said now the only person who can roll over an IRA to their own is a spouse. So if you name your son as a beneficiary of your IRA, they will have to take all of the payments out within a 10-year period. It doesn't have to be a 10th, the 9th, the 8th. They can take it all out the first year and pay taxes on it. They could wait, or they could, whenever they want to take it out, they can take it out and pay the taxes on that. So you parents of special needs children, this is somewhat of a silver lining. If you have a 401k or an IRA, if you name a special needs trust for your developmentally disabled child, you must have proof of that. Guardianship works fine if you've been appointed as a guardian. You can name the trust for your special needs child as the beneficiary of all or a portion of your 401k, and they can stretch out those payments for their life expectancy. So let's say you had two children, one typically developing and one with a special need, and you had $100,000 in your 401k, and you had a house that was worth $100,000. I'm just making these numbers simple because I'm a lawyer, and that's why I didn't get a math degree. Okay, so two assets, that's all you have, and two children. The best thing to do in that situation would be to leave your house, the $100,000 house, to your typically developing child, who would then sell the house and put $100,000 in their bank account. If you left the 401k or IRA to your special needs child, then they could put that into their trust and take distributions on it each year, and only pay taxes on the amount of the distribution, and not be bound by that 10-year distribution rule. It's a very new, and we move slowly in the law. So to me, this came out in Secure Act 2.0. So it's kind of a new thing that's out there. To be safe, what I do is I create a special trust for Joe, a standalone trust for Joe that mom and dad can name the IRA or 401k as the beneficiary of, just so that's very clear and concise. So this is something many of my clients, houses and 401ks and IRAs are the biggest assets they have. Some other folks might look at using life insurance to fund a special needs trust for your developmentally disabled child. And if you do use life insurance, a second to die policy is one where it doesn't pay out until the second death, until both the husband and wife are gone. And that's kind of the time that you would need to have that trust or have those funds available for Joe. Again, I'm going to stop here and offer it up for questions. If any of you have put any of those in there, I'd be happy to answer them if I can.
Thank you, Lorna. That was a lot of information.
Sorry,
Great. No, it's wonderful. I had a handful of questions, but
We have not received any through the Q&A, so
okay.
let's share yours.
Well, I think you kind of answered that question when you're talking about background checks, being a good citizen, that, if someone is going to go for guardianship, that's required. It's not just required for conservatorship, it's required for guardianship as well.
It is.
Okay.
They don't want, if you are not a good citizen, they don't want you to be, because the state of Missouri is giving up they have look out for you. They want to look out for Joe.
Yeah.
So they don't want to be negligent and let some criminal be looking out for Joe. Not good for Joe.
And when you talked about conservatorship and really just assets and finances, how does the Mo Able accounts?
The Mo-able accounts are good. You can avoid having to do any type of special needs trust with those, but they do have a payback provision. They're not as it's almost like a 529 plan that many of you might know about for colleges. You can do a Mo-able account, and then that money can be used for Joe without the need of having to draft a trust.
Okay. You talked about the marriage thing, which I'll be honest, I didn't know about driving as well. If you have a full guardian, that removes your right for potentially getting your driver's license. So
They'd like to have you reserve those rights. Those are the three. If you want to reserve the right to marry, to vote, and to drive a car. There's a presumption that you should be able to do those three things. So if you get a full guardianship, the judge will always ask from the bench if you don't bring it up first.
Jumping around. Was there any other? Again, if anybody has any questions, this is the time.
We have one. Is it necessary or recommended to hire a lawyer to file for guardianship?
I've never seen it done without a lawyer. I don't know if it's absolutely required. I think probably it is necessary to have one. I know in probate court, you can do a small estate affidavit without a lawyer, but I've never seen a pro se guardianship petition. I just haven't.
And then another question, if you have the health directive and financial durable trust for your son, should you somehow designate someone other than the parents too, in case something happens to the parents?
Yes, absolutely. And any durable power of attorney I do for any of my clients, whether they're developmentally disabled or not, I always have a succession of agents to serve. So it might be mom and dad as co-agents, either can serve independently, and then you might name brother as the backup in case mom and dad both can't, and maybe even sister as a backup to mom and dad. Absolutely.
Okay, and we have one more question. If you are filing for guardianship for a 22-year-old developmentally disabled adult, do the biological parents have to be notified?
They will be notified, but they have no more rights than anyone else. Once the child turns 18, they are considered an adult. So there's no claim that parents have the first dibs on the person, but the petition will ask who is the natural mother and who is the natural father. And the court will require that you give them notice of the hearing. So they could show up at the hearing and contest it. That would be considered a contested one. But there's no requirement that the natural parent be awarded guardianship or conservatorship after the child is 18.
How often do you see guardianship reversed?
In situations where someone's had a car accident and they're temporarily incapacitated in the hospital, then we restore it. But I've not seen too many reversed. I've had rights reestablished, some rights restored. But as far as reversal with developmental disabilities, that's not likely.
Okay.
Mental illness, yes. I mean, we're always hoping for better drugs for schizophrenia, other mental illnesses. So that one would be more likely.
And then we have another, and she says, I apologize if you said this in the beginning, but do you only petition in St. Charles County or also in St. Louis County? Do you recommend any attorneys that can file in St. Louis City or County?
I stay away from St. Louis County and St. Louis City as much as I can. There's an attorney in St. Louis County, Beth McCarter. I don't have her phone number with me, but she's very good, Beth McCarter. I would recommend in St. Louis County.
And then Gregory has asked, will we be able to get a document of this presentation? Gregory, there won't be a document, but we will be able to share a recording if you're interested. We could share the PowerPoint, but that won't get you all the good stuff. But we will have a recording. And then Laura has asked, can you give an estimate of how much it costs to hire a lawyer for this petition?
Well, I wanted to bring up the filing fees first because honestly, that's a very high filing fee. But again, that pays for the guardian ad litem, the attorney that the court appoints. And the judge will always ask the guardian ad litem, the attorney, are the fees, the standard fees sufficient? I really don't know what they pay the guardians. I think it's maybe $150, $200 of the fee. It usually runs with the sheriff's fee, the filing fee, and the attorney's fees. It's right around $1,000. And that is an expense that the protectee can pay. So like in St. Louis County, if the child isn't on SSDI or anything yet, the county will actually pick up the fee for it in the county. In St. Louis County and St. Charles County, you have to petition for that, and it's a big deal. You have to fill out a financial report to say why you can't afford it. But I would say $1,000 is pretty typical.
That's all the questions from the Q&A.
Well, thank all of you for being a wonderful listening audience. I appreciate it. And good luck to all of you and your goals to provide the best that you can for your family members.
Thank you very much for all the information.
Sure.
That was wonderful. So if anybody is interested, these are the open house in St. Peter's will be April the 3rd. We have an open house in Lincoln County for September 11th. And then this is the big one of more information. Our annual transition planning conference will be held on September 27th. So we'll have more great content like Lorna provided today at the transition planning conference. So now, good night. Thank you.